Topic is Digital Personal Data Protection Rule 2025. So personal data, we everybody know, we actually deal with this on our daily basis, like your phone number, your email address, your locations, your like medical history, your passport or KYC, all are your personal data. And when we talk about the digital personal data, when your personal data is available digitally or in the automatic world, then it is called digital personal data. And we all know when the personal data is available digitally and with the era of the robot, with the era of the technology enhancement, AI, ChatGPT, and everything, so your personal data always tend to be at the risk of loss of your personal data. So in that case, there is the law which governed by the government coming from the Ministry of Electronic of Technology, that they issue in 2023 one act which is called Digital Personal Data Protection Act 2023, that has been issued in August. After that, the rule thereunder, which is issued in just 13th November 2025. So if somebody asks you what is a personal data and how we are going to protect the personal data in this world where we are dealing like personal data, we are sharing our personal data on day-to-day basis to, maybe if we go to the shopping mall, if we go to the movie tickets, if we go to like just open our account on Instagram or Facebook, and wherever we go, maybe if we go to the bank, when we open our bank demat account, the saving account, we share our data, we share our information to them. And when you will know, when your data get shared to somebody else, some other company, or maybe there is a hacking of your data, so just to protect your personal data, the Personal Data Protection Act and the rule has been governed and the issued by the government. So if I talk about the why we are going to and what is the meaning of digital personal data protection rule, we just discuss about it. So if I go down, so this is the background. Just like I already discussed, in August 2023, DPDP Act was passed, but it was not operationalized. Why I'm saying that it is not operationalized? Because there is no manner was given how to deal with the act, how to deal with the provisions. The law said that you have to give to the notice to the data principal. I'll tell you in the later slide what is data principal. The law says you have to give the notice, but the manner and the way in which the notice has to be given was not clearly mentioned in the DPDP Act. That's why they was going to bring the rule also. And when we have also sees in the different act like the Companies Act or any other act and the IT Act, always the rule also follow them. So when we read the act, we have to also read the rules also along with them. So the DPDP Act was passed but not operationalized, and the rule was about to come to give the effect of the DPDP Act. In January 2025, draft DPDP rules was given to the public for their comment, for their opinion. Always something come, regulation come, the legislature always put to the public for their comment, for their opinion. So January 2025, it was placed before the public for their comments, for their opinion. And November 2025, 13th November 2025, Ministry of Electronic Information Technology has issued DPDP Rule 2025 to keep the operational and the effective manner to DPDP Act, which was issued in August 2023. So this was the background. So when I will see DPDP, it means Digital Personal Data Protection. So the short form is DPDP. So we are going to like refer multiple times in the later slide, the DPDP Act and the DPDP rules. So that's why I give this background to everyone knowledge. The implementation time. So we need to understand whenever government, whenever any authority come with any act or the rules, they do not just pass the direction like you have to follow immediately unless it is very easy to implement. It is very smooth to implement. They give some window. This gives some, time to implement the rule, to implement the act, because we will discuss the activity, the procedure, the action that has to be taken by the data fiduciary is in very comprehensive, is very in it's a vast list, and assessment need to be done, and protocol, security protocol has to be done. So all of these things cannot be done on immediate basis. So that's why the government has given the implementation timeline wherein the company can approach, company can see where they are stand today and where they can meet as per the law requirement. So the rule one, so the implementation timeline is given like this. So the rule 1 and 2 and rule 17 to 21 is immediately effective. And the rule 1 and 2, it's nothing but a definition provision. Rule 17 to 21, a company need not to do anything. It's a like data protection board, a board which will govern, which will listen the complaint of the data principal to whom the data belong. So data protection board will be set up by the law, will be set up by the MIT, and they will entertain the complaints coming from the data principal. So that a company or a entity or a data fiduciary doesn't need to do anything in that. After 1 year, from 30th November 2025 to 30th November 2026, after 1 year, consent manager related conditions and consent manager related obligations will be implemented. If a company want to become a consent manager, I'll explain later on what is consent manager. If the company wants to become a consent manager and what's their duty, what's their obligation, what condition need to meet, they have to they the all the procedure and the protocol is given in the rule, and they have to work like right now today from the day this day one, because after 1 year you do not get the plenty of time to implement those conditions and the obligation. The timeline begin from today, and this will implemented, this will be give effect after 1 year, which is 30th November 2026. Now the ultimate window, the ultimate timeline, if I talk as per this DPDP rule, is after 18 months, which is like your 1.5 year, 30th May 2027. All the operational obligations, all the core operational obligation, or I would say the entire rule will be effective. So the rule 3, rule 5 to 16, rule 22 to 23, all the operational activity will be applicable on the company, on the person to whom the data belong, consent manager, and everyone. So the phase 3 is the window which is given by the law, which is, I think, in my opinion, is very less, because 18 months is nothing. Time will pass like very soon, and a company has to implement so many things, like to give the notice to the customer, give the notice to the user, and to prepare the governance redressal mechanism, to implement the security protocol, and so many things is given in the rules, and there is a separate protocol, separate procedure for the minor, for the legal, for the person who come with a disability. So all of these things need to implement like just after 18 months it will get affected. So the company need to be get ready like from the day one. If we see these terms, these terms seems to be very, difficult to uh, understand, but it is not. I'll explain with the help of the example. You are actually a person who give your information to whom the information belong. You are the principal, you are the owner, you are the master. That's why you are called the principal. The person who understand, who decide what need to be done with your information, to whom it needs to be given for the processing, is the person who has a right to take a decision about your information, about the data principal information is called the data fiduciary. It could be anyone. It could be a company, it could be a government, it could be a politician party, it could be like your Facebook, your Instagram, your social media, where you put your information. They decide what need to be done about your information. They process your information, they process your video, and then just they post it. Data processor is the person, is the entity who is actually processing your information. The company is using or taking the help of the cloud to store the data, to process the data. Cloud is nothing but a data processing, who is making available the information when it is required, who is storing the information. So data processor is nobody but a person or an entity or anyone who is processing your data. So consent manager is a person who is registered with Data Protection Board. Data Protection Board, which is immediately effective. I just discussed in the previous slide. Consent manager who is registered with Data Protection Board, who provide a platform to the data principal to give the consent, to manage the consent, to review the consent, and withdraw the consent. Very important part. You go to the app, you allow everything, you give your consent. When you download an app, you give your consent. Okay, that is not the company is doing to for which you have downloaded the app. There is a there is a platform which is giving this facility. For example, there is an account aggregator like a Finfu or any other entity who is giving the facilitation of reconciling your bank statement and then giving to the bank. When you actually download your bank statement from the account aggregator, and then aggregator will give the bank statement or reconciliation statement to the bank. So they are acting as an intermediary, they are acting as a platform to manage your consent, and it give you a opportunity, it give you a facility. There you can go, you can manage your consent, you can see your consent, you can withdraw your consent, you can review your consent. So all of these things will be managed by a consent manager. Significant data fiduciary. There is a two type of data fiduciary. One which is data fiduciary. You can call it simple data fiduciary. Another one is significant data fiduciary, who handled your significant data, like your political data, your like government related data, or for the international like scheme related data, government scheme related data. So those type of data fiduciary are called the significant data fiduciary, and they have like different type of compliance requirement given by the law. Not different, but a major kind of compliance requirement given by the law. For example, you download your Aadhaar from UDI. UDI, maybe the government will decide who will be the significant data fiduciary. Government can notify UDI as a significant data fiduciary. Why? Because they are handling their Aadhaar related information, and Aadhaar is very significant. We all know about it. So these are the important terms we are going to discuss in upcoming slides: data principal, data fiduciary, data processor, consent manager, significant data fiduciary. So let's just start. What is the obligation of data fiduciary? That's the important part. Why? Because the major responsibility and the major work that has to be done by coming the DPDP Act and the DPDP rule is actually putting on the shoulder of the data fiduciary only, because they have to deal with it, they have to do the security protocol and everything. They have to ensure that the act is not getting violated, and they have to ensure there is a protection of the data that they are collecting. So first responsibility or the first obligation comes with the data fiduciary is the consent notice. They have to give the clear consent notice to data principal that I am collecting your personal data. This is your notice, and in the notice they will give the clear line why I am collecting your data, what type of data I am going to collect. Going to collect. What is the category of the data? The purpose of collecting your information. So all of these will be the content of your notice. Also, the communication link would be there. The URL of the website or the app would be there, and the link also for withdrawing of their consent, for right of access and complaint also. Like basically the link for withdrawal means the consent manager link, and the right and access and complaints, where they can just open the link and they can go to the data protection board and they can file the complaint also if they think their data getting misused. Then the other sort of responsibility comes with the data fiduciary is security safeguard, very clearly, very specifically mentioned by the DPDP rule is the security protocol. They have mentioned the word encryption, they have mentioned the word of the audit logs, they have mentioned the masking, like unauthorized access restrictions. All of these protocol has to be implemented if they have not yet implemented yet by the company who is collecting the data. Whenever there is a breach, then another standard of procedure there is given by the DPDP rule. And also when they are dealing with the vendor, because company is not itself collecting the data, they are also dealing with the different outsourced vendor also. So they are just not doing the security protocol by itself. They have to ensure that the vendor also to whom they have the agreement also need to adhere, that vendor also need to adhere to the security protocol as given by the DPDP rule. Now, the intimation of the principal data breach, as I told you, there is a separate protocol, separate procedure for the data breach. Whenever there is a data breach, they have to intimate to the data principal and the board immediately. There is a no halt. They have to like just on the getting of the on the getting informed about the breach of the personal data, they have to inform them. And after later on, whenever the data protection board give the longer period or within a 72 hours, they have to report the detailed report. What actually happened, when happened, what is the time, what is the location, what is the measure they have taken till yet. And all of these things they have to give to the board within 72 hours. Then the minority and the person with disability, they are also being protected by this DPDP rule. And very clearly, it is being mentioned that the consent of the parent in case of the minor would be considered as a data principal, would be considered as a very verifiable consent. If the minor comes or his parents, his or her parent come, that we have to open the bank account in a bank. Okay, so what is the duty of the bank? Bank has to see, first of all, whether they are lawfully parent or not. First of all, they have to see whether the parent is adult or not. They have to consider that criteria, and then after that they have to see whether but they have to identify with the available information, the age, the other factor, the KYC. If they do not have the registered or the available information, then they can ask also with the help of the DG locker also, or the information given by the minor or the parent itself. So the other procedure, this different procedure also be followed by data fiduciary. Now the security safeguard, like um, if you are an IT person, if you are like dealing with the IT governance, then that's a very important part for if an entity dealing with, for example, with the AI, with for example, for robotic analysis and all of these things, then the security safeguard is going to be very strict for them and for the other organization also. So the technical and the organization measure that has to be placed by the data fiduciary, they have to protect the data by using the encryption, by using the masking. They have to monitor the log system, who come, when come, what they have done with the data. So all of this comes with the monitoring and log system. They also need to ensure that the that the outsourced vendor to whom the data has been shared is also following the same security protocol, same security standard. Because when I am collecting your information and I'm sharing that particular information after getting your consent to my vendor, then it's my responsibility to ensure that the vendor is exactly doing the same security standard, is meeting the same security standard, which I am on the stage of the data fiduciary, on the step of the data fiduciary, I am doing uh, at this stage. And then restrict who can access the data system. That's very implied that you cannot just anybody cannot just come and just access the loan origination system or LMS or Tele. It should be like authorized. Only the authorized person can access a particular system. Nobody can just come and just log in and just access the customer related data, vendor related data, HR related data. Maintain backup for the continuity. What happened when there is a disaster happen, when somebody hack your data, when there is a malware. So always should be business continuity, or the backup should be there so that you can protect and you can smooth your business also. Also, they have mandatorily listed in the rule that you have to keep the personal data, your logs, for at least 1 year. That's a very, um, uh, the very vague or very unclear statement from the previous law or from the previous direction, that nobody know for which period the company need to retain the logs. Now it is being clearly said that the logs has to be kept for at least 1 year. So now we can communicate also to our respective client, also to our friends, also to our colleagues, also that you have to, boss, like keep your data, keep your log, keep your the what history of the investigation and everything for at least 1 year. Nobody can question you because it's coming directly from the DPDP rule. Normal scenario, 1 year period is given, that you have to minimum 1 year retain the logs. Personal data, traffic data, your processing log must be retained for minimum 1 year. It is being clearly laid down. Also, after 3 years, just like you can delete your data after passing of the 3 year or the DPDP Act, whichever is latest. But before deleting your data, they have to intimate you that I am going to delete your data 48 hours prior notice. Very important part, significant data fiduciary. As I at the start of the presentation, as I conveyed that there is a two type of data fiduciary. One is data fiduciary, a simple data fiduciary. Another is significant, who is dealing with your significant data. They have to do some additional obligation. It would be like your appointing a data protection officer. Each and every data fiduciary need not require to appoint the data protection officer, but a significant data fiduciary has to appoint a data protection officer. They have to do a independent they have to appoint an independent data auditor also. Like we have internal auditor, statutory auditor, different auditor. They have to appoint the independent data auditor also. They have to do yearly data protection impact assessment also. That will that impact assessment will tell what type of personal data they are holding, where they are storing, who is getting access, what security protocol they have taken. So this will be a huge exercise. Data protection impact assessment. Carry out periodic compliance review. They have to do like compliance review, that each and every organization does that. Then you have to maintain the strong operational measure, like different administrative measures also, additional condition as set up by the government. The rule and the right and the duties of the principal. Being a part of the data principal, uh, you always be aware what type of information you are giving. You cannot impersonate any other person. You cannot like hide important information. You cannot file the false complaints. Your information always be correct. So this is your duties, and this is not your right, but this is your duties. Always give the rightful information. Now the data fiduciary consent manager always publish the request, what is the DP username identifier, what is the meaning of the identifier? When you go to the bank you give you a UCIC, a unique code. This code will identify your identity, that you are this type of customer, you have taken this loan or you have opened this account. So this is the unique identifier, will be published by the concerned manager or the duty fiduciary. If you have any governances, then they will solve within 90 days. The buffer is given the 90 days in the rule itself. Then the right of the data principal, they have the right to access their principal, they withdraw, they can erase, they can put the complaint to the board also, they can file a complaint to the data fiduciary also, the consent manager also. They can nominate a representative also, that on my behalf that person will give the information. So this is the right and the duty of the data principal. Very huge thing and a very important and charming thing about DPDP is the penalty, because if data fiduciary fails to maintain the security protocol which has been given by the DPDP rule and the Act, 250 crore rupees penalty can be imposed, up to rupees 250 crore penalties can be imposed on data fiduciary, which is not a small amount actually if we see about it. If they do not report the breach, or if they violate any child related provision, that can lead to 200 crore rupees, which is again not a small amount. Then other type of violation can attract rupees 50 crore. So the penalties listed by the rules and the act is not simple penalty, it's not any imprisonment is given, discipline action, no, but the rupees 250 crore, 200 crore, 50 crore, which a small organization cannot even afford, if we see that. So they have to like comply in true letter and spirit this DPDP. So what is the next step, or what should action actually today, if we are sitting on 26th November 2025, what we need to do as a professional suggestion, if I give you, first of all, we should know, being a data fiduciary, being a consent manager, we should know where we stand today, where I am lacking behind, what type of data I am storing, I'm getting, where I'm storing, what security protocol I have right now, what type of notice I give today, what type of information I publish on the website, and what is my grievance redressal mechanism if somebody come and complains to me. So I should be aware where I'm standing today. So my professional suggestion would be, first of all, we need to do a DPDP assessment, a DPDP compliance assessment, so that you get to know where we are standing today, and after that you can work on the implementation on the basis of the gaps that has been identified in the assessment procedure. So you can do like from the start also, if you think that you are like 100% sure and I just need to implement in the 18 months, you can do that also. But before starting anything, we should always be remember where we are existing, whether we are like on the 0% or the 50% or 100%. You should be aware of that. That will enhance your confidence also, only being registered as a consent manager or a data fiduciary. And on the part of the data principal, I always be aware about my right. I cannot just give my consent just by allowing or just by clicking the terms and condition. I should be always be aware what type of data I am actually giving, to whom I'm giving, and what sort of information they are going to get from me. So awareness is very important on the part of the data principal. So if I talk about the next step that I just discussed, we have to build a readiness assessment is very important. DPI assessment for the significant data fiduciary, strengthen your security protocol, governance roles means the policy, DPO appointment and all of this appointment, independent data auditor appointment, vendor management along with the DPDP rule, cross-border data transfer rule, So all of these are your next step for the DPDP implementation. So here we end our presentation on DPDP Rule 2025 and DPDP Act 2023. If anybody has questions, they can also contact me at the given address, at the given contact number or the email address.